People ask all the time, Gordon, what do I do if somebody threatens me? What am I allowed to do? What does the law say I can defend myself with, force or deadly force? The first and most important thing to understand is that against mere words alone, you are not justified to use force or deadly force. What it takes to use deadly force is a reasonable belief you're in immediate danger of death or serious bodily injury. And words alone, even if they are, hey, your tie looks dumb and I'm going to kill you, that does not rise to the level of a reasonable belief you're about to die. However, if that threat is coupled with an action, such as, that's the dumbest tie I've ever seen, I'm going to kill you, and then I grab you by the tie and pull you, well, that's a whole different ballgame. So keep in mind, just words alone are not going to constitute a reasonable belief, but if you couple those words with an action, that can rise to the level of a reasonable belief you're in immediate danger of death or serious bodily injury. So there's all sorts of variables that can come into play as well. For example, if you're attacked by someone who's much bigger and much stronger than you, or if you're a 90-year-old, 70-pound woman and you're attacked by a prime Mike Tyson, all of these sorts of things can come into play that may make you more afraid by someone who threatens you. But keep in mind, the base rule is the same. Words alone do not meet that level of a reasonable belief you're about to die. There has to be some kind of overt action. Another factor on top of all this is whether or not you have to run away before you're allowed to defend yourself. So for example, if you are threatened and there is some overt act that rises to the level of reasonably believing you're about to die or get seriously hurt, do you have to run away before defending yourself? Well, luckily here in Texas there is the stand your ground doctrine, or as it's codified, no duty to retreat. And if you qualify under the statute, you do not have to run away before defending yourself. How do you qualify? It's actually pretty easy. If you're the good guy in a given encounter, you should be able to meet these requirements. Number one, that you have a justified use of force or deadly force. In other words, you're actually defending yourself, right? You're not going out and assassinating someone. Number two, that you're not committing any other crime. This is stop the guy who's robbing the liquor store when the clerk pulls out the shotgun from shooting the clerk and saying, I was just standing my ground. No, that's dumb. We don't want that to happen. So you can't be committing any other crimes. Number three, you have to be in a place where you have a legal right to be. For example, I can't break into your house in the middle of the night and when you pop out of bed, blast you and say, oh, he was coming right for me. No good. I have to be in a place where I have a legal right to be. The fourth and final rule is that I cannot provoke the attack against me. Now that kind of sounds bad because if you say to yourself, well, if I'm in a shouting match or an argument with someone, it sounds like I'm provoking them, right? No. The Texas Supreme Court defined what this word means, provoke, and it means you can't try and trick someone into attacking you because you secretly want to murder them all along. That's a totally different ballgame from, flipping people the bird or saying nasty things. I'm not telling you you should do that, but you can do that, and that is not considered provocation under the law. However, I can't say I've always wanted to kill that guy over there. I'm going to antagonize him until he attacks me so I can kill him. You cannot do that. That is a provocation. So if you meet those four requirements, you're allowed to stand your ground and defend yourself without having to run away. No discussion of threats would be complete without talking about road rage. Road rage happens all the time. Something about Texas roads just drives people insane. And so there's all sorts of threats you'll get, verbal, physical, someone may flip you the bird, things like that. But what happens if during a road rage incident the other person displays a handgun or some other kind of firearm? What do you do then? Well, again, we go back to what we were talking about at the very beginning. There has to be threat plus an overt action. If I'm yelling all these nasty things at you for cutting me off, and I'm not doing anything else, that's probably not enough. But if I pull a gun as I'm shouting nasty things at you, there you have an overt action and a threat. So in that situation, you would be able to defend yourself with deadly force if you reasonably believed you were about to die. Now also keep in mind, in a road rage, everyone has a different story. And so that's why it's very, very important to make sure that you call the emergency hotline and talk to your program attorneys before you talk to the police. Because if your story is, we got in a road rage incident and I shot the guy, instead of, we got in a road rage incident, he displayed a gun, and then I had to defend myself, those are two completely different sounding stories, but they talk about the same incident. So that is how critically important it can be to contact your attorney before talking to the police if this happens to you.